professional responsibility students on the Code of Judicial Conduct. In this particular lecture, I'm going to be hitting kind of a random selection of specific points from the Code of Judicial Conduct that tend to pop up as multiple choice questions on the MPRE. The Code of Judicial Conduct is tested on the MPRE. According to the examiners, based on the percentage of the 60 questions, it shouldn't be more than 4 questions or so. The Code of Judicial Conduct is really, I think, extensive enough to be a whole semester course. So it's very hard to give it as much attention, to go through all the provisions of it in preparation for the MPRE, and I'm not sure it would be a very good return on investment for my students. Instead, I think you should focus on the rules that are not reciprocal with the model rules for lawyers. So you already know the rules about ex parte contacts and things like that, and focus instead on rules that are heavily tested. What I'm doing for my students is recording some lectures on a few specific rules that get tested a lot and that have pretty detailed or complex provisions that are not obvious. And I'm going to skip over ones that I think you would have guessed anyways, about how judges shouldn't take bribes and assault people and commit crimes and things like that, that you almost surely would have guessed right without knowing anything at all when you take the MPRE. Then we have some that I don't think merit their own video, but are worth just mentioning once. So here we go on our fast tour through a few assorted and heavily tested, commonly tested provisions of the Code of Judicial Conduct. The first is about soliciting donations for judges that are running for a spot in the states. About half the states or more have elected judges. And so judges are not allowed to solicit donations for campaigns. Neither are lawyers who are running for judge who aren't judge yet. You can't hit up your clients, for example, and ask them to contribute to your campaign. Now, a campaign, a separate kind of PAC or election campaign can do it, but we can't have the judge personally soliciting donations, nor are you allowed to solicit donations for nonprofit organizations. And so this could be your favorite charity or a cause, social reform groups like the ACLU or the Federalist Society, and so forth. The judge should not be shaking people down for donations. And so that's 4.1. And then from 4.1 to 4.5, there's a number of provisions about not being involved in political activities. And so now sometimes this can be hard for some people, other people it's not, right? Sometimes there's people who are just very successful lawyers who then run for a judicial spot or get appointed or something like that. And it's kind of easy for them to stay out of politics. Other people, the reason they got to become a judge is that they were very involved in politics throughout their lives. They're kind of an operative within their party. And so it's very hard for them to stop talking about politics and being involved and showing up at the convention for their party, their state convention, and things like that. And judges aren't supposed to do it. And by the way, this is now applied to posting things on social media like Facebook and Twitter. Judges should not be pontificating about political activities and political candidates for Congress or the governor or the president or things like that. Judges and their clerks cannot conduct their own factual research or investigation for pending cases, and this includes internet research. And we have a sort of recent ABA ethics opinion about this that I may make the subject of a separate lecture. because it's very nicely written and goes into great detail about it. And there's a few judges who have been kind of egregious violators of this. Now, please note, judges can do their own legal research. So judges can go find cases that the parties didn't bring up, can use Westlaw and Lexis and so forth. What we really don't want is for the judge to visit like the scene of an accident and have a look for themselves, or go out and talk to people who they feel like should have been witnesses in the case or know a lot more. So anything that's factual research, whether it's online or not at the library, or talking to people and things like that, the judge shouldn't do, and the judge shouldn't be sending their clerks or other people to do it. Okay, next, judges cannot serve on boards of directors or as managers, officers, or employees of any business entity, with minor exceptions for the judge's family business and certain nonprofits. In other words, when you become a judge, if you have been serving on the board of a business, you have to resign your position from the board of directors. You cannot be, it doesn't matter that you think you could be fair, or that they rarely litigate or something like that. We don't want judges serving on corporate boards of directors. This is for for-profit corporations. Nonprofits are a little different, and so it's not unusual that we see judges who are on the board of universities and law schools. My law school has one or more judges who serve on the board. Its board of directors or board of trustees. Some of the big hospitals in Houston where I teach have federal judges on the hospital, serve on the hospital. And so that type of thing is allowed, but not for a judge to serve on the board of Microsoft or IBM or Apple or a big corporation like that. Also note that there's an exception if it's the judge's like family business. That might be different. Judges can't serve as executors of estates or administrators or trustees of estates except for kind of immediate family members. And so we shouldn't have judges, even if the judge agreed to do this before they became a judge, they can no longer serve as the executor of estate. Remember that sometimes executors are designated when someone drafts a will, and it could be years, many years before the person actually passes away and their will matters or goes into probate. And if the person has become a judge at that point, or even if there hasn't been a lapse of time, judges can't be the executor of estates or trustees of estates. That's 3.8. Judges should not praise or criticize jurors for their verdict except in a written court order or opinion in a proceeding. And so if the jury does something that the judge doesn't like, they rule the wrong way, and it could be jury nullification, it could just be that it was a hotly contested case and the judge thought they were going to should go the other one way and the jury went the other way, the judge should not go all Hollywood on them and gasp when he hears the jury's verdict and ream them out or tell them what a bunch of idiots. Nor should the judge say, good job, guys, thank you for upholding our fundamental values of fairness and justice and stuff like that. Judges can thank jurors for their service, but should never give them a gold star for reaching the right decision in a case or doing the right thing, or criticize them. And then the exception is, as you know, in most jurisdictions, there's procedures for judges to set aside a verdict because it seems to contradict law or something like that. And so judges have to put that in writing and enter a decision that will very often be appealed. And so if you're a judge and you're disgusted with what the jury did, then you need to do a JNOV or a judgment notwithstanding the verdict or something like that, and set aside the jury's verdict and put it in writing, and don't just yell at the jury and conversely tell the jury like how proud you are of them for doing the right thing in a case. Okay, next, judges shall not make use of court premises, staff, stationary equipment, or other resources except for incidental use for activities that concern the law, the legal system, or the administration of justice, or unless such additional use is permitted by law. And so we had some controversial cases. A long time ago, there was a judge that was a high-profile member of one of the larger religious denominations in the United States, and that denomination was having sort of an engrossed in an existential struggle for whether it was going to become more conservative or more liberal, its position about the biblical inerrancy and things like that. Coming up to a convention, and this judge kind of was one of the big operators to force through a particular change or doctrinal change in the denomination. And there were allegations that this judge had sent letters on court letterhead or the judge's letterhead and so forth, which the judge disputes later. But that's the type of thing we're talking about is if you're just doing your personal correspondence and it's not really part of your judicial functions, you shouldn't be doing that. Nor should you, like if your chambers has a copy machine, don't start taking gig work from law firms in town to do their copying for them on court equipment. Don't use your court staff to do chores for you, personal chores and so forth. Incidental stuff, no big deal. You want to photocopy your kid's picture, you want to have your kid is selling candy bars and for their school band, and you want to have the box of candy bars on your desk. Nobody really cares. And you find a funny cartoon and you want to make a photocopy of it instead of email it or scan it in or for something and send it to a friend. If it's an incidental thing, we don't care. What we really don't want is judges routinely like using the courthouse premises for other things. As soon as possible after taking the bench, the judge must divest herself of any investments, i.e. substantial stock holdings or ownership shares in a business that could require frequent disqualification or recusal of the judge. In other words, if you own a lot of stock in a company when you become a judge, kind of any company, you're probably going to have to sell off that. When we say divest, we mean you sell off your stock holdings, and whether it's publicly traded or you own an ownership share in a local business or something like that. Now, if this is something that's never going to appear before your court, then maybe we don't care. But if this is a company that could present issues with disqualification, it's foreseeable that you could get a case involving this company that you own a lot of shares of stock in, then you don't wait for the case to come up. When you become a judge, you actually have to dump the stock. Okay, you cannot, as a judge, serve as a character witness for anyone in trials or other proceedings. Why? Because the view is that judges have a lot of prestige in our system, especially in our legal system and in our society in general. And it's kind of a super character witness, right? To have a judge testify on your behalf and say that you're truthful and honest and can be and trustworthy and so forth. So you shouldn't, if you're a lawyer and you're looking for character witnesses for your client or witness or people to boost the credibility of key witnesses in your trial whose impeachment is going to be questioned or who are going to be impeached on cross-examination, then you need to bolster them by having a character witness for them. So, something like that. No character, don't use a judge, and the judge should decline to do it. Judges cannot use or disclose non-public information gleaned from their assigned cases. For example, judges must not engage in insider trading or stock purchases based on non-public information learned while adjudicating a matter. And so as a judge, you see a lot of information that other people, the general public, doesn't get to know. And so you could see evidence coming through in a case and you could realize, wow, this case is going to be really devastating for this particular company, or is going to be a big bonanza for such and such a company. Don't go making stock trades, purchases or sell-offs based on the information you're getting in your courtroom. 1.3 is avoiding abuse of the prestige of judicial office. You should not abuse the prestige of judicial office to advance the personal or economic interests of the judge or others, or allow others to do so. And I'm going to give a couple examples of this. And I don't want the whole rule itself has a lot of subsections, but I want to highlight one for you that has shown up on the MPRE as a multiple choice question. And it's an example that's given in the comment to 1.3. It would be improper for a judge to allude to his or her judicial status to gain favorable treatment in encounters with traffic officials. And similarly, a judge must not use judicial letterhead to gain an advantage in conducting his or her personal business. And so let's talk about the first one. This is a classic scenario where you have a judge who gets pulled over for speeding. The officer walks up to the window and wants license and registration, and he says, you know, I'm a judge, right? You are in my courtroom all the time, or something like that. And they should not use the fact that they're a judge to get out of a ticket. That's what we're really talking about. Don't bring it, you're not allowed to even mention, you know, I'm a judge. Now, of course, a number of judges have, depending on your jurisdiction, have a license plate that is a special issue judiciary branch or judicial branch license plate. So if you have one of those, the cop who pulls you over knows that this is at least a judge's car. So they already know it. And of course, the cop may recognize you as a judge, but you should not try to leverage it with the cop. And the same is true if you're applying for a mortgage or a refi or a personal loan or something like that. Don't mention that you should not use the fact that you're a judge to get favorable treatment from lenders, let's say. Okay, next. This is about gifts, and there are questions about this on the MPRE, and I don't want to go into it too much detail here. I actually suggest, and I have students ask about the gift rule a lot. I'm going to hit the highlight for you, but this 3.13 may be one of those rules that you want to just really actually look at carefully before your MPRE. Judges cannot accept gifts that could undermine judicial integrity or even have the appearance of undermining judicial integrity. And then there's exceptions for small gifts like plaques, trophies, certificates, holiday gifts from relatives and friends, free tickets to fundraiser banquets, and other free items and discounts that are kind of available to everyone else. When I talk about the fruit basket rule and when I'm teaching the lawyer advertising rules for fruit baskets for referrals and so forth, I mentioned that maybe sending a fruit basket to a judge is not that big a deal. As a judge, you don't have to turn it. Now, if a party shows up in your court on the day of trial and says, "Judge, here's this wonderful fruit basket," you shouldn't take anything from the party. I don't think you should take a box of donuts or a free ballpoint pen from one of the parties appearing before you. But there are lawyers who send kind of nice holiday gifts to a long list of like former clients and friends from law school and people at other firms and law professors and judges and so forth, and they send a fruit basket to everybody. So if it's not, we're not singling out the judge, then we kind of don't care. And we kind of don't care if you invite the judge to speak at your organization's little event and you give them a little plaque or plastic trophy or something like that that says, "Thanks for being a great pillar of our legal community." Judges can accept those types of things. Holiday gifts from relatives and friends, free access at fundraiser, a seat at the table at a fundraiser event that other people might have to pay for. All of those types of things are okay, but nothing that would seem to undermine confidence in the judge's fairness. Also, even though you can't accept substantial gifts, as I said, with some exceptions, keep in mind that you can be paid for your speaking engagement. So you can receive an honorarium. Judges get book royalties when they publish books. If a judge teaches a course as an adjunct professor at a local law school, they can get paid for doing that, and so forth. I did a whole other lecture, recorded a lecture about 3.6. But in case you haven't watched that, I want to mention this because this is tested very, very frequently on the MPRE. A judge must not be a member of any organization, such as a dining club or country club, I'm paraphrasing the rule here, that discriminates based on race, sex, gender, religion, national origin, ethnicity, or sexual orientation. So no judges who are Klan members, obviously, but also things like dining club. The more common examples are dining clubs and country clubs that discriminate. There's an important exception, of course, to this rule for attending an event on an incidental basis at a facility of one of these organizations that discriminates, because you're just in the audience and it doesn't look like you're endorsing their discriminatory practices. Also, membership in churches and religious organizations is permissible, even though many churches in some sense are discriminatory. And so for example, they will only ordain, have male-only clergy. They require people to sign a statement of faith in order to become members. Very, very common in churches that they're only going to admit you to formal membership in the church if you believe all the stuff that their church believes. And so in that sense, is that viewpoint discrimination? Sure, but it falls under our religious exception. And as you know, many religious groups have sexual taboos and prohibitions like homosexuality or cohabitation before marriage or on marriage and divorce. And some groups require their members to practice, to marry within their faith and all sorts of things like that. And we're not going to tell judges that they have to change their religion because they become a judge. Okay, that concludes our sort of quick overview of a few key points that you should know for the MPRE.